The only
and
thing
just try to
is,
give mercy.
we don't have to sentence.
All rise, police court's back in session.
Anyway, I'll talk with you.
Thank you. Be seated. Kevin Boyles? Is Kevin Boyles here? Alicia Blaylock, or Bullock? Alicia Bullock?
She's in custody, Your Honor.
So this one didn't show up yet?
Correct.
You didn't- Papers? No, not yet. We wait until the others.
Your Honor, Tim Gibbs on behalf of Alicia Bullock. Judge, this is 24 CF 798. First, we're here for arraignment. We'll enter a not guilty plea and leave this set for pretrial. Request 15 days for any pre-arraignment motions, as well as demand a trial by jury. I did file a motion for bond. I did file it yesterday. We had noticed a conflict of interest that we had to get resolved before I could file that bond motion. I did file a notice for today, but again, I did file that notice yesterday. I'd like to proceed on the bond motion, but I leave that to the decision of the court.
All right, this is 24 CF 798, State of Florida versus Alicia Bullock. Ms. Bullock, you're charged with burglary with an assault and criminal mischief over $200 and resisting an officer without violence. Your attorneys pledged you not guilty. And you said you have a conflict of interest, or?
We had noticed one. We resolved that. We were keeping Miss Bullock as our client, but I did file a bond motion yesterday. I filed it yesterday because I had to wait for us to resolve that conflict before I could file a bond motion.
Okay, what about the state ready on a bond motion for that?
You may not have seen it. I filed it yesterday.
What bond does she have now?
Judge, the only cash professional bond that she has is on the count 1, burglary with assault or battery. It's $20,000. This court set that at a pretrial detention hearing earlier, a few weeks ago. We're requesting that it be modified to a signature bond, and I have argument that I'm prepared to make.
Judge, well, how long has she been in jail?
35 days, thereabouts.
She's currently charged with a burglary of dwelling with assault or battery, which is a first-degree felony punishable by life in prison. But I was willing to extend an offer to reduce that and maybe do 6 months in jail instead of life felony.
Is that just, what about the other 2 counts?
Well, the other 2 counts, criminal mischief and resisting without violence. So they're both misdemeanors, the other 2 counts.
What about an offer on those, time served or something?
Yeah, that would be time served on the misdemeanors and then 6 months for the felony.
I'm not sure if she's ready to accept that this afternoon. She'd like some time to think about it. She would still like to see about the bond motion. So again, I leave that to the
Time
court.
served on 2 counts and reducing a life felony to a what? A
A third-degree felony. would be-
third-degree felony, 6 months
Which
jail
felony,
sentence.
I'm sorry?
F3L4,
What's-
burglary,
Burglary of a structure?
yeah. Unoccupied.
6 months with credit for time served.
She's supposed to have surgery this month. That's one of the other reasons that we were asking for a bond reduction, Judge. She's not prepared to accept that plea today.
No bond reduction, thank you.
Understood. Thank you, Judge. You'd serve 4 more.
June 24th.
Judge, with the estimated credit that she has, she does want to accept the state's offer this afternoon. We can bring her back at the end.
Okay,
That's fine.
We can bring her back at the end, Judge.
all right.
We'll bring you back at the end, okay? Come back.
Got Michael Chester. This is 24 CF 758. Mr. Chester, you're charged with possession of a controlled substance and driving a license habitual, second or subsequent conviction.
Your Honor, Tim Gibbs on behalf of Mr. Cheshire. We did get an offer. I'd like to go over that briefly with him. Complete both of these today. Bring my- All right. Judge, he's just going to sign his written plea real quick. Let me grab a pen.
Yes, sir.
The agreement calls for 90 days in jail for all of these counts, Judge, concurrent and time served.
And if I can ask the clerk to make sure that there's no other cases that Mr. Cheshire has, so we can,
There is
Just
none.
today's date, please, sir.
What is
I
it?
think there might be 2 MMs.
There's 2 case numbers here. Go ahead. 24 CF 758, 24 CF 999. I don't believe there are any other cases, but let's check.
There ain't.
There shouldn't be.
That's it.
So it
24.
would be a plea to both cases, Judge.
Let me sign mine here.
Great.
Let me get him to sign it real quick.
Plea interlude and all that shit.
Mr. Chester, would you raise your right hand, please, to be sworn? You swear the testimony you give before this court is true, so help you God?
Yes, sir.
Thank you. I'll wait for that.
Yes, sir.
If I may approach, Your Honor. Score sheet included, this does represent a downward departure.
Mr. Chester, you want to enter a no contest plea in 24 CF 758 to possession of a controlled substance and driving license suspended or revoked. Both of those going to be third-degree felony pleas.
Yes, Your Honor.
And in 24 CF 999, fleeing and attempting to elude, and driving license suspended or revoked, habitual traffic offender. And that was same as count 2 in 24 CF 758, driving license suspended or revoked, habitual traffic offender. So you want to enter a no contest plea to those 4 counts, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form? Did you read and sign
Did
this
you just sign
form?
that?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts the plea. You are judged guilty on both cases, all counts. Since 90 days Okaloosa County Jail with credit for time served concurrent on all cases, all counts. Total $200 cost of prosecution, court costs, $250 PD fee, all due within 180 days of release or to judgment.
Thank you, Your Honor.
So,
Yes,
okay.
sir.
Stay out of trouble. Out of
I
trouble.
always do that.
This is your copy if you want.
Yes, sir.
All right, good luck.
Next one is Dale Jenner.
I'm sorry, Your Honor?
Is it Dale, oh, excuse me, Kenneth Dale?
Yes, Your Honor. Your Honor, Tim Gibbs on behalf of Kenneth Dale. Judge, this is 24 CF 748. If I could have just one moment, I believe we have an agreement. If you do, if you're already, are you already going to do counseling? So if they want to. Okay. We get the evaluation. So that's what you want to do, sign right there.
Do we have some VOP evidentiaries this afternoon?
Yes, Your Honor. Mr. Allen, we have an agreement. Mr. Arney, I believe he's going to enter a plea to the bench. Mr. Gamble may enter a plea to the bench, and Mr. Fizer may still very well be a hearing.
Is this Kenneth Dale?
Yes, Your Honor.
Mr. Dale, would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God?
So help me God.
Thank you.
I approach, Your Honor.
This is State of Florida versus Kenneth Dale, 24 CF 748. You want to enter a plea of nolo contendere to resisting arrest without violence, a first-degree misdemeanor, and the state is going to dismiss count 1, battery on a person over 65, correct?
That's correct, Judge. And for the record, the reasoning for dropping the battery charges, it's the victim's request. I spoke with the victim, which is the defendant's mother.
Okay,
and she is in agreement with the agreement.
all right. Did you read, Mr. Dale, did you read and sign this plea and sentencing agreement form?
Did you just sign that, sir?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea? Are you aware of the rights you're waiving by entering this plea?
Rights to go to a trial, right to make the state prove the charges against you, where you're waiving those rights by entering a plea to get to the probation and resolve the case. You can appeal anything that is illegal that the court does. You have the right to appeal a sentence within 30 days. But you are waiving your right to appeal any substantive other issues in the case if you enter this plea.
Okay.
You understand that?
I understand
You
that.
understand the rights you're waiving by entering this plea? They're all mentioned in this form. You understand fully the rights you're waiving by entering this plea? Has anyone forced you or threatened you to enter this plea?
No.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? No. Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Count 1 is going to be dismissed by the state. Count 2, you are adjudication withheld, sentenced to 11 months, 29 days probation, $50 cost of prosecution, $220 court costs, $150 PD fee, have a mental health evaluation and a recommended follow-up treatment, and that's it.
We request a waive cost of supervision, Judge.
Waive cost of
Thank
supervision.
you, Judge.
Okay.
So you'll just meet with probation and they'll get you.
Thank you, sir.
We did have a bond motion filed, but we'll withdraw that now, Judge, as it's moot.
Sir.
All right, Dristan Derek. This is 24 CF 796, State of Florida versus Dristan Derek. Mr. Derek, you're here on arraignment. You're charged with 2 counts of possession of a controlled substance without a prescription and possession of narcotics equipment. Looks like, is that 2 third-degree felonies and a misdemeanor, first-degree misdemeanor?
Yes, Judge, and the offer in that case is an adjudication of guilt, $615 in court cost, and credit for time served.
If you want to enter a no contest plea to these charges, the court will adjudicate you guilty and sentence you to time served, no jail time, no more jail time, and no probation, $615 court costs. Okay, would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God.
Sir.
You want to enter a no contest plea to charge of drug possession of a controlled substance without a prescription, 2 counts, both third-degree felonies, and 1 count of possession of narcotics equipment, a first-degree misdemeanor. You understand that? Are you aware of the rights you're waiving by entering this no contest plea? All right. Has anyone forced you or threatened you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Court finds the plea is freely and voluntarily entered. Court accepts it, adjudicates you guilty all 3 counts, sentence you to time served in the county jail, $615 court costs payable within 180 days or to judgment. Okay?
Yes,
Thank
sir.
you. Yeah. Javaris Durham.
He's an inmate, Your Honor. I thought he was in jail. Somebody told me he was in jail. That is him right there walking out.
All right, good.
We're happy to see that he's out always, Judge. Your Honor, Tim Gibbs on behalf of Mr. Javaris Durham. Judge, this is 24 CF 739. Judge, he has a new case, so we'll enter a not guilty plea, leave this set for pretrial conference. I am not sure if we're appointed on his new case yet. Because I represent him here, we'd have no objection to the court appointing us on his other case. I just don't have that case number. If the clerk could potentially help.
He's here on 24 CF 739, driving license suspended.
Yes, Judge, he has a new trafficking case where he's been charged with trafficking that we haven't been appointed to yet.
In my division,
Yes, Your Honor.
I'll appoint public defender and
Thank you, Judge.
set him for June 24th. How about that?
All cases, yes, Judge.
Okay.
Thank you, Your Honor. Do you need my card?
Dustin Emerson.
Yes. Your Honor, Tim Gibbs for Mr. Dustin Emerson. Judge, this is 24 CF 784. I'm not sure if we received an offer on this case.
Yeah, it's 60 months DOC. Yeah.
Okay. Judge, we'll enter a not guilty plea, request 15 days for any... We'll enter a not guilty plea, request 15 days for any pre-arraignment motions, and demand trial by jury.
24 CF 784. Mr. Emerson, you're charged with possession of a weapon by a convicted felon.
I'm sorry, Your Honor.
I was just telling you what he was charged with, and your attorneys pledged you not guilty, so June 24th.
Thank you, Judge.
Thank you.
I'll get all that case law that we talked about. That should be everybody from me for this afternoon. I'm sorry, I was talking to the bailiff.
I guess 3 whoa means I ain't taking that deal. Matthew Furkel.
I'm showing that.
Alabama's working on there.
This is an out-of-state fugitive from justice. What is the situation on this, Mr. Sprous?
Alabama's applying for the governor's warrant.
I think we can only hold him 30 days, and then we got to release you on bond, I believe.
That's correct, Judge.
How long has he been in jail?
9 months.
9 months on
Do we know
this?
if Mr.
Not on
Furkel has
this.
signed a waiver of extradition?
Have you signed a waiver of extradition?
24 days ago.
24 days ago, you signed a waiver.
I signed one 22 days before that.
My notes say that he didn't sign, so,
Okay.
and it's, if you do sign, it makes it easier.
So I didn't sign 24 days ago. I went in front of the judge and signed in front of a lady.
Let me point the public defender to check into this, and we need to get him out of here.
So I was supposed to be released tomorrow. They told me if they didn't come and get me by the 10th, I would be released tomorrow.
That would be 25 days if he signed it 24 days ago, Judge. They generally serve 25 days on 30.
Well,
If the jail is supposed to release him tomorrow, can we set him for the 13th or the 20th? I'll likely be here the 20th already.
Oh, that's crazy.
13th or the 20th?
13th is Monday. Well, I believe we have jury trials scheduled.
Not the 13th now, that got continued.
That got continued.
Let me see. Yes, that one's been continued, so,
The jail can still let you out. And
Yeah,
that's
he-
what I want to clear up. If the jail says that they can let him out because of the 30 days, they should let him out tomorrow because that'll be 30 days.
that's fine. If,
Yeah,
Yeah.
if we can make sure the court minute sheet
What
states
they-
that there's no objection to release him if he's hit his 30 days.
What they told me was if they don't come by the 10th, I'd be released, but the warrant would stay active until
Yeah.
I had it taken care of in Atlanta.
You'd have to go take,
And
yeah,
it's not Alabama, it's Atlanta.
Atlanta.
Yes.
okay. He can be released on the,
I mean, I don't
whatever,
have a
by
problem coming
tomorrow.
back here.
tomorrow.
So,
What's
then,
that?
Judge, let's put this on the 6/24 for pretrial.
So
If they
now-
do release you, call my office.
So now if I come back on the 24th with an active warrant, am I going to be arrested?
Call my office, we'll talk about it. We'll talk about it.
Okay, thanks.
Thank you, Judge. They may be dead.
What about Benjamin King?
They may be dead.
I'm sorry, Benjamin King, Judge.
Yeah,
Mr. King's my client. Judge, I'll be entering a plea of not guilty on Mr. King's behalf. I request 15 days for any pre-arraignment motions and a demand trial by jury.
all right, this is 24 CF 735. You're charged with fleeing, attempting to elude with sirens active, driving suspended habitual as a habitual offender, and possession of narcotics equipment. Your attorney's pledged you not guilty. Was set for June 24th.
Thank you, Judge.
you, Your
Continue to stay in contact with my office, okay?
Yes, sir.
The next one is Cameron Kostler.
You have a number where we're not appointed yet.
Is that right? Is it Cameron Kostler?
It's Kesler.
Kessler? Okay. You are charged in 24 CF 816, 2 counts possession of controlled substance without a prescription and 1 of possession of narcotics equipment. Is there an offer from the state?
Yes, Judge, adjudication, 615 in court costs, credit for time served.
You want to accept that? Court costs, no jail time, credit for jail time served and no probation? You do? You'll be adjudicated a felon, you understand that? Would you raise your right hand to be sworn? You swear the testimony you give for us court's the truth, so help you God. You want to enter a no contest plea to the charge of 2 counts of possession of a controlled substance without a prescription, third-degree felony, possession of narcotics equipment, first-degree misdemeanor. Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty, all 3 counts. 615 court costs. You have 180 days to pay it or to judgment. Credit for time served. Concurrent on all counts. Thank you.
Thank you.
See.
Have a score sheet, Judge.
Okay. Jeremy Lang. This is 24 CF 775, State versus Jeremy Llewellyn Lang.
Okay. Judge, it looks like this is going to be a plea. I went out and spoke to Mr. Lang. I'd made some recommendations in the cases, but he... I'm sorry, sir, what? All right, if this is what you want to do, why don't you get your signature there? He's aware of that he has a right to take the case to trial, have me research it further. I explained all that to him. We do have an information filed in the second case that's set for May 30th. Since we have an information file, we can go ahead and arraign him and take his plea on that today.
Is that case number on this plea form?
It is, Judge.
Mr. Lang, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God.
Yes, sir.
Thanks.
No, they're run concurrent, sir. It's a total of 6 months. You do have a little bit more credit on the older case than you have on the newer case. So when I told you a little less than a month credit, that was based on the newer case.
State would stipulate to giving credit for the oldest.
Okay. So, Madam Clerk, did you get that? He's going to get credit for the case from the older case. It's essentially going to be coterminous.
This is 24 CF 775, 24 CF 930, State versus Jeremy Lang. Mr. Lang, you want to enter a no contest plea to battery on a law enforcement officer in 775, a third-degree felony, and in 930, battery on a detainee, a third-degree felony. So you want to enter a no contest plea to those 2 charges, correct? Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams did for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty on both cases. Sentenced to 6 months county jail with credit for time served, concurrent on both cases. Standard court costs, cost of prosecution, PD fee, each on each case to 180 days to pay it or to a judgment, and adjudicated guilty on both cases. And credit for time served runs from the case that gives him the most credit for time served.
Thank you, Judge. All right, sir, good luck to you.
Thank you.
Antonio Lee.
Hey, Mr. Lee. Just come stand over by here, okay? I'll do all the talking for you.
This is 24 CF 828, State versus Antonio Lee.
Yes, sir, Judge. I'll enter a plea of not guilty on his behalf, request 15 days for pre-arraignment motions, and demand trial by jury.
All right, he's charged with petty theft, third or subsequent conviction. Your attorney's pledged you not guilty, Mr. Lee. We'll see you June 24th. Thank you.
Thank you, Judge. And I'll get that one. Okay.
Michael Manning.
That officer direction.
Is Michael Manning here? No bond capias on Mr. Manning. Kashaya Matthews. Is that right, Kashaya?
Kashaya.
Kashaya? Okay. This is 24 CF 805, Kashaya Matthews, State versus Kashaya Matthews. You're charged with possession of cocaine, a third-degree felony, driving license suspended or revoked, and possession of more than 20 grams of marijuana. Is there any type of offer for her?
Yes, Judge. As a withhold 18 months probation, 6 months driver's license suspension, substance abuse evaluation treatment, court cost of $615, and maintain gainful employment.
How much probation?
18 months, Judge.
Are all these third-degree felonies?
Judge, I believe one is a
Driving.
third-degree felony and the other are misdemeanors.
The
Possession of greater than 20. I apologize.
I
That
got
is a
2
third-degree.
felonies and a misdemeanor.
That is correct.
So the misdemeanor one could not be 18 months probation. It would have to be 1129 concurrent or something.
That's correct, Judge.
All right, if you want to accept that, withhold adjudication means you will not have a felony conviction or a misdemeanor conviction on these cases. Withhold, if you want to enter a plea, I'll withhold adjudication, give you 18 months probation, 6 months driver license suspension, have a substance abuse evaluation, and $615 court costs. You got all during the probation to pay it if you want. Take the whole time. You want to do that?
I would like to plead not guilty. I'm in the process of acquiring an attorney.
Okay. Set you for 6/24. June 24th. You're going to get what you got? So you got an appointment with a private attorney?
Yes, sir.
Okay. Okay. Tell them what that offer was. It may not be good after today. I don't know, but
That offer is going to stay open.
Stay
I'm not
open?
gonna-
Okay, we'll talk to an attorney.
And can I ask a question?
Yeah.
I heard you guys were saying more than 20, but it says less than on my paper.
Well, mine says more than 20.
So if it's pointing towards the number, it's.
Oh, no,
greater
it
than.
says the word less than.
Let me see your paper. Well, all right. The way this information is, she's got one felony and 2 misdemeanors. It says less than 20 grams, count 3. The docket says more than, but the information says less than, less than.
Judge, the state's going to amend the offer after review of the case. We'll do a withhold court cost credit for time served.
You want to do that? No probation, no nothing, no, all it is you've already done your time and just standard court costs. And I'll withhold, which means you don't have a conviction. You want to do that? Okay. So you would be pleading to 1 felony and 2 misdemeanors, and I'll withhold adjudication, which means you don't have a conviction, and credit for time served and court costs, and you give you 180 days to pay it or it goes to a judgment. You want to do that?
Yes, sir.
Okay. Would you raise your right hand and be sworn? You swear the testimony you give for this court is true, so help you God. All right. You want to enter a no contest plea to the charge of possession of cocaine, a 3rd-degree felony, and driving license suspended or revoked, a 1st-degree misdemeanor, and possession of less than 20 grams of marijuana. I think that's 2nd-degree misdemeanor, isn't it?
If it's less than, it's a first.
So first, what was the driving license suspended? That's a 2nd-degree misdemeanor, isn't it?
Should be, Judge, yes.
Anyway, you want to enter a no contest plea to those charges, correct? Are you aware of the rights you're waiving by entering this plea? Right to a jury trial, right to have the state prove its case beyond to the exclusion of every reasonable doubt.
Yes, sir.
Right, there's other rights, such as right to remain silent, right to put on your, take the stand and testify if you want to, right to cross-examine state witnesses, right to have the state prove its case beyond and to the exclusion of every reasonable doubt. You're waiving those rights and other rights. You understand that? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
What kind of work are you doing?
I work at Juicy Crab. GCC.
How old are you?
I'm 22.
22. Were you thinking about reducing that felony to 1st-degree misdemeanor? I think you were thinking about that. Yeah. Approach.
I concur with the court's judgment, so we won't need a score sheet if you just please to I'll reduce it to just a possession of paraphernalia.
All right. I saw that the state was kind of thinking about something, so instead of a felony, you're pleading to possession of paraphernalia, so 3 misdemeanors, okay?
Yes, sir.
No felonies, 3 misdemeanors.
Yes, sir.
And that's,
Thank you.
okay. So I'm going to accept the plea as freely and voluntarily entered. Court accepts the plea, withholds adjudication, sentences you to time served. Was it time served? Did you serve time in jail?
Yes, sir.
How much time?
I was only there for a day and a half.
Okay, time served in the county jail and concurrent on all counts. Standard court costs, and I give you 180 days to pay it before it goes to a judgment.
Yes,
So
sir.
you come up here when you feel like it, pay it within 6 months. Otherwise, it goes to a judgment. It's better to just work and pay it off, okay?
Of course.
So
yes,
you
sir.
got no conviction, it's 3 misdemeanors, okay?
Yes, sir. Thank you so much.
All right, thank you. Next one is Kristen Miller, I think. Kristen Miller, okay. 24 CF 776. You are charged with possession of cocaine, a third-degree felony, and possession of narcotics equipment. Mr. Williams?
Judge, I'm going to enter a plea of not guilty. 15 days for any pre-arraignment motions and set it for trial by jury.
Okay, June 24th, thank you.
Thank you. All right, come see me again before then, okay?
right. Dana Riling? This is 24 CF 810, State versus Dana Riling. You are charged, Ms. Riling, with possession of cocaine, a third-degree felony, and possession of less than 20 grams of marijuana. Is there an offer on the state with this?
Yes, Judge. It's an adjudication, court cost, credit for time served.
You want to enter a plea to that with that offer, credit for time served, meaning no more jail time, probation, court costs, and credit, and that's it. I'll give you 180 days to pay it. Would you raise your right hand to be sworn? You swear the testimony you give for this court's true, so help you God. You want to enter a no contest plea to possession of cocaine, a third-degree felony, and possession of less than 20 grams of marijuana, a misdemeanor. You understand that? Has anyone forced you or threatened you to enter this plea? You have to speak up a little bit.
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, adjudicates you guilty, sentence you to credit for time served, standard court costs, give you 180 days to pay it before it goes to a judgment.
Thank you.
Thank
May I
you.
approach, Judge?
Yeah. Okay. So that was Miss Riling, I hope.
Yes, Your Honor.
Okay. And now we have 24 CF 749 State versus Kevin Rogers.
Yes, Your Honor. Mr. Rogers is present and approaching.
Okay.
We're going to enter a not guilty plea, request trial by jury, and pretrial conference date of 6/24.
Mr. Rogers, you're charged with possession of a weapon or ammo by a convicted felon. Your attorney's pledged you're not guilty, 6/24, okay? June 24th.
Your Honor, the next one on the docket is Xavier Thomas. Since we have been in court, my assistant has texted me that Mr. Thomas has called, broke down on the side of the road coming from Alabama, and that his bondsman has also contacted our office as well. He's trying to see if he could get a ride here, trying to get the matter remedied, but at this point, since he did call in, we would ask that the court consider just continuing his arraignment. If he makes it in before the end of the day, fine, but if not,
State has no objection, Judge.
All right. We'll do that.
thank you, Your Honor.
Daniel Wesson. This is 24 CF 783, State versus Daniel Wesson, charged with aggravated assault, police officer.
Yes, Your Honor, we're going to enter a not guilty plea, request trial by jury.
June 24th, thank you.
Yes. And I'll come out and we'll watch videos and stuff.
Willie James Williams.
Mr. Williams.
Your Honor, Mr. Williams, before the court on 24 CF 757, we've reached an agreement in this matter.
Mr. Williams, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God?
Yes, sir.
This is State of Florida versus Willie James Williams, 24 CF 757. You want to enter a no contest plea to possession of a controlled substance, a third-degree felony, and possession of drug equipment, a first-degree misdemeanor, correct? Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Did anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers done for you on your case?
Absolutely.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge guilty both counts. Sentenced to 30 days Okaloosa County Jail concurrent. $515 court costs, $100 cost of prosecution, $150 PD fees. Okay.
We had a couple that we have. Big. Diggs. Your Honor, Tim Gibbs on behalf of Wayne Diggs. Judge, this is 20 CF 2011. We recalled him from this morning. I had mentioned earlier this morning that I tried to file a bond motion that apparently didn't go through until this morning. The state
Okay.
had some time to try to verify the information that we were alleging in support of our bond motion. I don't know if the state's had an opportunity to do that yet.
Your Honor, upon better review of the case, I'm just objecting to the offer for the VOP is 14 months in the Department of Corrections. So whatever has happened in the other case is independent from the decision here in this court. So I'm objecting to a release. It's
Your Honor,
Hang on one second. I want to make sure I understand. So right now, this is this is set for a VOP evidentiary, isn't it?
This is VOP and arraignment this morning.
Arraignment.
Or the arraignment was 2 weeks ago. This was set for a bond hearing today. I just didn't file the motion until
What
this morning.
bond has he got right now?
No bond, Judge.
No
It's a
bond?
VOP, so it's discretionary with
Oh.
the court.
And what's he looking at if he does get convicted of the VOP?
So, Your Honor, on this case right now, he scores 13.95 months. The state's offering 14 months even. The charge, the VOP is based on new charges in Georgia involving possession of marijuana, possession of firearm, and possession with intent to sell, manufacture, or deliver. Our understanding is that Georgia is kind of waiting to see what we do here. Additionally, Judge, on this case, on the underlying charges, my understanding is that he's paid restitution.
all of it.
That he's paid restitution. And we're just asking for a bond. He will live in Atlanta. Again, he does have
Please
family
let me
here.
speak.
Mr. Diggs.
I
you'll
will,
get your
but just
chance.
hang on one
You'll get your
second.
chance. I'm just trying to let the judge know what's going on, okay?
What kind of restitution is there on possession of a weapon?
That's on the that's on the
I
underlying
got
charges
you.
in this case.
I got you.
And I believe he does want to address the court if the court wants to place him under oath.
Your Honor.
Hold on, let him place you under oath first.
Mr. Diggs, would you please raise your right hand and be sworn?
Yes, sir. Yes, sir.
Your other right hand.
You're the right hand.
You swear the testimony you give for this court's the truth, so help you God?
Yes, sir. Keep it a billion.
Okay, what you want to tell me?
Sir, I am currently speaking and working with Judge Gerald of Gainesville Superior Court and the U.S. District Attorney's Office for Dirty Cops and Miss Crystal Coley calling me out my name several occasions at the beginning of this case, calling me a nigga. That's number one. Number two, can I finish?
I
Can I
was just going to
finish?
advise you against being careful, but if you want to
Yes,
say that,
yes, sir.
just know that everything can be
Number
discussed.
two, I've had witnesses in court every time I've stood before you, and you told me at the first beginning of my case here, you said, Mr. Diggs, I don't want to see you again, and after you pay restitution, I will get you off probation. But Hurricane Sally happened, and we could never get in contact with you, and Ms. Coley would not answer the phone for my probation officer in Fulton County, sir.
When you say,
Now,
hold on, Mr. Diggs, when you say Ms. Coley, who do you mean?
Crystal Coley,
Who is she?
my probation officer, who she shouldn't because it's a conflict of interest.
Do you mean Ms. Conley?
Miss Conley, yes, I'm saying her name wrong. I apologize, Your Honor. Two, I have 3 very serious health conditions. I have congestive heart failure to the worst degree. I have AIDS to the worst degree, and I have high blood pressure. I am not getting any type of medication. For 2 months I've been in your jail, no medication. My blood pressure yesterday was 218 over 185. Sir, if you're not going to keep your word and take me out probation because I paid all my restitution, please give me a bond so I can go to the hospital. Please.
You weren't before me.
It might have been Judge Flowers.
It was some other judge,
Yes,
not
sir.
me.
It might have been Judge Flowers.
Yes, sir.
So George is kind of waiting around to see what we do, huh?
That's what I understand,
Yes.
Judge. That's also kind of been my experience with Fulton County.
What's his bond at? Right, no bond?
No bond, it's a VOP, Judge.
I don't know if he can make any kind of bond that I could set. You don't have any money, do you?
Yes, I have my people here, my family here, and I've had people here, both federal and citizen, civilian, since the beginning of this case, sir.
He's got family members here?
Yes, Your Honor. If y'all would stand, please.
So y'all live up in Atlanta, Georgia area? Yes. And y'all, what relationship are you to Mr. Diggs? Brother?
Got a better idea.
Is he going to stay with you if I let him out on bond?
Judge, we
Will
just
I
got...
be today?
Yes.
Okay.
Judge, the state just extended a new offer to Mr. Diggs. If he were to admit the VOP, the state would recommend time served. I believe he wants to accept that.
All right, see, worked out.
I'm not leaving today, sir. Can I go to the hospital in 6 hours from here?
What I'm going to do is sentence you.
And he'll get you.
I'm going to sentence you to time served, and unless you're being held on something
No.
else, you should be.
No, I'm not.
Do you want to admit that you violated, I swore he
Yeah,
violated.
you already-
Do you want to admit that you violated probation?
Sir, yes, sir.
Are you aware of the rights you're waiving by entering this admission?
You're
Right to a
waiving the
hearing?
Go to a hearing.
Yes, yes, sir.
Are you under the influence of any medication or drugs that prevent you from
No,
knowing what you're
sir.
doing?
I don't do any type of cocaine, meth, or needles.
Yeah. I got you. Are you being threatened or forced to enter this
No,
admission?
but I have been threatened by your sheriff department several times,
But not for this plea,
but
right?
not for this plea.
All right.
No one threatened you to enter this plea?
No,
have they?
sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Or Fizer? Mission is freely and voluntarily entered. Court accepts it, sentences you to time served in the county jail.
Sir,
Thank you, Judge.
thank you, sir.
All right, thank you.
Good luck, Mr. Diggs. Good luck. And then the other one we had from this morning was Ms. Bullock, or earlier this afternoon was Ms. Bullock. You getting her? All right. So do you still want to do the 6-month thing? I'm sorry.
Let me see Mr. Gibbs and Miss Leone up here.
Judge, she just needs to sign the written plea.
Okay. Why is she
I
crying?
just need you to sign right there for me, okay? If I may approach, Your Honor. Score sheets included, it does represent a downward departure for uncoerced plea bargain.
This is State of Florida versus Alicia Bullock, 24 CF 798. Ms. Bullock, are you able to enter a plea right now? You seem very upset.
Yes, I am very upset because I'm going to lose everything that I own, and I'm not going to be able to go to surgery. And I've worked very hard for the last to stay out of this place. I mean, I do weekends in jail, do community service, whatever I'm going to do. I've got responsibilities outside, and I will lose everything that I have if I take this plea. And I did not hit her. I was defending myself in this case. I was trying to reconcile this relationship with Miss Morrow.
How much, it looks like it's a credit for time served type sentence.
She served about 35 days, Judge. The deal calls for 6 months. For the court's information, the bond hearing, Ms. Morrow is currently incarcerated for possession of controlled substance. There were other arguments that we were using to attack Ms. Morrow's credibility. The underlying case, it's a he said, she said. The facts that they do agree on apparently are that Ms. Bullock did go over there to try to bring Ms. Morrow some food, and then a physical altercation occurred.
And she's bit me, broke my nose and everything.
Unfortunately, the victim in this case, I understand is a defendant, but it's a victim nonetheless, so it's got rights as a victim. She communicated with my office that she is objecting to any bond for this defendant. She's afraid of the defendant, and she wants to go forward with the with prosecution. So, although she scores, I extended the offer of 6 months in jail. But if she doesn't wish to take that, then we have to go forward with the first-degree felony. And the victim did have injuries, visible injuries, so it's not like only he said, she said, or she said, she said.
Visible injuries, I believe, were mostly a bloody nose. It's not like this was Ms. Bullock breaking into a house. She was already invited in and then was asked to leave, and then the altercation occurred.
She could get a furlough for the surgery. I wouldn't object to that.
You would not object to a furlough?
No, I wouldn't. I don't know if the court is agreeable to that.
When
but-
is your surgery supposed to be? May 29th?
Yes.
How long would you need before and after? He usually agrees to furloughs if we stipulate. We can work on the terms. Otherwise, Judge, since the state's willing to stipulate to a furlough, I think we can work on those terms and submit a
All
stipulated order.
right, I'll grant you furlough to have your surgery, okay?
We'll get those stipulated terms.
This is
to you, Your
going
Honor.
down from a life felony to a third-degree felony for 6 months credit for time, 6 months county jail. And so you want to enter that no contest plea to these charges, burglary with assault or battery, excuse me. You're in a plea to burglary of an unoccupied structure, a third-degree felony, criminal mischief, a second-degree misdemeanor, and resisting and without violence, a first-degree misdemeanor. So a third-degree felony and 2 misdemeanors. You want to enter a no contest plea to those charges.
Do you still want to do that? And then you'll get a furlough. We'll have the terms agreed upon for the furlough.
Yeah, the week before my surgery. The flesh
We've got
wound.
just
We'll work
enough
that
time to
out.
do We've
You
got
want
time
to do that, correct?
We'll have that paperwork done tomorrow.
You want to do that, Ms. Bullock?
Yes, sir.
Did you read and sign this plea and sentencing agreement form? You did? You have to talk out into the microphone.
Yes, sir, I did.
Has anyone forced you or threatened you to enter this plea?
No, I just want this to be over with.
Pardon?
I just want to resolve this matter, sir, because I didn't go over there to hurt her. I was defending myself.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, I know exactly what I'm doing, Your
Are
Honor.
you happy with the work Mr. Gibbs has done for you on your case?
Excellent.
Court finds the plea is freely and voluntarily entered. Court accepts it. On count 2 and 3, you're sentenced to time served concurrent. Count 1, you're sentenced 6 months county jail, credit for time served, $100 cost of prosecution, standard court cost, $150 PD fee, all due within 180 days of release or sent to judgment. And the state defense can work out a furlough that she needs to have her surgery.
We'll work on those terms tomorrow, Judge.
Okay.
We should have an order tomorrow.
All right, thank you.
Order done.
And it was adjudicated on all 3 counts. Who else we got, Mr. Gibbs?
Your Honor, I believe a Mr. Bowles was called earlier and didn't answer, but I believe he's here now. Mr. Bowles? I don't believe he's represented, but his friend approached me in the hallway.
Let's see, this is Kevin Bowles.
Sir.
You're charged with burglary of an unoccupied conveyance and petty theft, a misdemeanor. Is there an offer for the state, from the state?
Yes, Judge. Adjudication, 515 court costs, credit for time served.
If you want to enter a plea, I'll adjudicate you guilty and sentence you to time served. I mean, no more jail time, no probation, nothing. 515 court costs, I'll give you 180 days to pay it before it goes to a judgment. You'll be a convicted felon and a misdemeanor. You want to do that? Would you raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God. You want to enter a no contest plea to burglary of an unoccupied conveyance and petty theft, correct? You understand that? A 3rd-degree felony and a 1st-degree misdemeanor. Correct? Mr. Sproul?
That is correct.
All right, you want to enter a plea to that? No contest plea? You have to talk into that mic.
Yes, sir.
You understand the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty both counts. 515 court costs, 180 days to pay it, and sentenced to time served in county jail. Thank you.
Thank you, sir.
May I approach, Judge?
Real quick. He's gonna have to take your fingerprints.
Anyone else here for arraignment that I didn't call their name? I don't think we have anyone else for arraignment, do we?
Judge, I don't have anybody else.
What about the 2 o'clock docket? We'll start with, you want to start with Mr. Austin? Who is that?
Oh, I'm sorry, Your Honor. Ms. Duffield was on this morning's docket, and
Hang on 1 second. Let me see who we got here.
it is Jessica Duffield.
All right. right, that's 21 CF 1612 and 21 CF 3015. Jessica Duffield on a VOP. Is there an offer on this?
There's an announcement, Judge. The defendant has provided probation, who provided me proof of her evaluation. There's no recommended treatment. Therefore, we're going to dismiss based on substantial compliance with probation.
You're going to dismiss your violation of probation. Any objection to that?
No, Your Honor.
All right.
And terminate probation.
And terminate probation. You're finished, okay?
Yes, sir.
Good,
Thank
thank
you.
you. Now, let's see, we got Gregory Austin, is that right?
Yes, sir, Your Honor. Brandy Merrifield on behalf of Mr. Austin and 23 CF 895.
What is this, a bond motion, or what kind of motion?
It's not, Judge. We filed a motion for statement of particulars and a motion for specific discovery.
Oh.
Should be a brief hearing.
Who's the prosecutor on the, okay, Ms. Barrett? All right. What's the state's, you read the motion?
Yes, Judge, we have. We did file an amended information yesterday, as well as a response to defense's motion for statement of particulars with some of the information that they were seeking. In addition, we would agree that some of these records they're seeking are relevant. However, a lot of those have information in them that needs to be redacted by hand, as it mentions other children that are not involved in this case. So that will need to be blacked out page by page and sent over. That's going to be a bit of a process, but we're not disagreeing that she's entitled that information.
And we have been in communication about the various documents. I did receive the amended information in the response, so we would just ask for an order in relation to the DCF records once ASA Berrickman has
All right,
an
well,
opportunity.
prepare me a stipulated order, y'all, okay?
Thank you, Judge. That's all I had.
You don't want to stick around and watch all this legal talent we got going here today? This outstanding judgeship? All right, you're excused. What about Brandon Lee Allen?
Mr. Allen, first, we have an agreement on Mr. Allen, Judge. While we're bringing out Mr. Allen, I have 4 on the afternoon docket, 2. Mr. Allen is the first one. We have an agreement. Mr. Arney is my second one. He wants to enter a plea to the bench and proceed to sentencing today. Mr. Fizer, I believe, would still be a hearing, and Mr. Gamble would also like to enter an admission to his VOP to the bench and proceed to sentencing today. We'll bring him out as we go. I guess that's the rest of the docket, isn't it? It's just me. Yeah.
I'd request Arnie first, just so I can get my officer out of here.
That's fine.
Okay, Mr. Arney, Daniel Arney, and that's 23 CF 2610.
I'd rather do Mr. Allen because he's already done. I just need Allen to sign. That's fine. All right. Your Honor, Tim Gibbs on behalf of Mr. Daniel Arney. Judge, this is 23 CF 2610. Judge, we're here for a VOP evidentiary hearing. We had tried to negotiate this out, could not reach an agreement. Mr. Arney would like to enter an admission of his VOP to the bench. Basis for the admission, Judge, is for not providing a urine sample and leaving the probation office before providing a sample. He's on probation for 2 misdemeanors, DUI and possession of paraphernalia. I believe the maximum sentence the court could give is 1129 plus 6 months on the DUI. Judge, we're asking essentially for time served. He's done some jail time. He's been in the jail for at least a few weeks, almost a month now.
What was it, some type of reduced down to a misdemeanor?
I believe one of the charges, I believe one of the felonies was reduced or was dismissed in exchange for the plea to the DUI and the POP. He was placed on a year of probation on
All right,
those 2.
Mr. Arney, would you please raise your right hand and be sworn? You swear the testimony you give for this court's true, so help you God.
Yes, sir,
You
Your
want to
Honor.
admit that you violated probation?
Yes, sir, Your
Are you
Honor.
aware of the rights you're waiving by entering this admission?
Yes, sir, Your
Anyone
Honor.
force you or threaten you to enter this admission?
No, sir, Your Honor.
Are you happy with the work Mr. Gibbs done for you on your case?
Yes, sir, Your Honor.
You want to enter a plea to the bench, which means there's no agreement between the state defense as to any type of sentence. I can give you whatever I feel like is legal.
Yes,
You
sir, Your
understand
Honor.
that? Okay. Court finds the plea is free and voluntarily entered. Court accepts it. What is the state looking for?
The state's asking for 6 months, Judge. The defendant
About to.
aware of the probation conditions, but he willfully violated. So that's why we're asking for 6 months. And he, if this were on felony probation, he would score prison. So that's why we're asking for that, Judge.
How much probation has he done already?
I would defer to probation on that. He's been on probation for 4 months.
And what was the total term of the probation?
1129, Judge.
1129?
Judge,
And,
Mr. Sprous has claimed that this was a willful violation. Mr. Arney did go to the probation office that day on his check-in to provide a sample. The sample was ultimately not provided, but he did wait. He did walk to the probation. I believe he actually
I
ended
came
up...
from the courtroom to there. It was for riding my bicycle with the open container.
The underlying charge on the DUI, Judge, was he was on a bicycle on the DUI. That's the underlying charge.
And I would add, Judge, that understanding that he went in to provide the urine samples, but he did not provide that urine sample even after he was told to wait by probation.
I tried.
He
It
didn't
took me
provide the urine
15
sample
minutes.
the next day, or the next day, or the next day. Still hasn't provided that sample.
Well, what I'll do is sentence you to time served for the violation and discontinue out the rest of your probation.
Thank you, Your Honor.
With a reinstatement, Judge?
Yeah, reinstate the probation, finish it out, and time, you've served how much time in jail?
He's got
50 days.
50 days, that's credit for time served for the violation.
Thank you, Your Honor.
And don't ride a bicycle drinking whatever you were drinking.
It was an open container, sir. I understand that now.
And
It's very clear. to
They
me.
don't want you in that probation officer any longer than you have to, so they say, wait, there's some good reason, don't leave till they say you can leave.
It was my first visit, and they told me that I could come back on the 13th to get assigned to probation officer.
Judge, I would ask if he is, if
Yeah,
he's going to give testimony that be put under.
He already
oath.
is.
Okay.
He's under
He already
oath.
is. He already is.
But
Yeah, you don't need to say anymore.
Okay,
Good.
thank you.
You won.
Mr. Berry,
He's on probation till December of 2020.
yeah, he's got,
A little bit time left.
yeah. And
Yes, sir.
Mr. Berry don't want you hanging around that probation officer office any longer than you have to. So if they say wait, they gotta make you wait there for some
Yes, sir.
reason. Don't leave.
He seen me that day.
Okay.
Thank you.
Good luck.
Thank you, Your Honor.
Hey, Arnie, Daniel, they got to talk to you first.
See, you're already leaving probation too early.
Good night, Your Honor. I'm trying, though.
Alan, yes, please.
All right.
Your Honor, Tim Gibbs on behalf of Brandon Allen. Judge, this is 16 CF 1400. We've reached an agreement if I can have just a minute to sign.
All right.
Just sign right there, so you have the 6 months of credit for all time served. If you want to send it to collections, we can. If not, we can ask 180 days to pay. Each time you have, the jail calculates that. Okay. They'll send you a letter. What's today's date? 5/9. So, yeah, if the calculation seems wrong, write me and I'll look into it. All right, appreciate it, Mr. Gibbs.
This is 2016 CF 1400 State versus Brandon Lee Allen. Mr. Allen, would you please raise your right hand to be sworn? You swear the testimony you give before this court's true, so help you God.
Yes, sir.
Okay.
If I may approach, Your Honor.
Okay.
Of course, she's included. It does represent a downward departure.
You want to admit that you violated probation, Mr. Allen?
Yes, sir.
Did you read and sign this plea form?
Yes, It's the one we just went over?
The one that he...
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
The right to go to a trial, because we had set it for a VOP evidentiary hearing today. The right to go to an evidentiary hearing. That's what we were set for today. You're waiving that by going to the 6 months.
Yes, sir.
All right. Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Static.
Court finds the plea is freely and voluntarily entered. Court accepts the admission, revoke and terminate probation, 6 months Okaloosa County Jail, credit for time served, $100 cost of prosecution, $150 PD fee, adjudicated guilty.
Thank you, Judge.
Thank you.
Outstanding monies to collection.
Yes.
Yeah, just wait. He may need your fingerprints. Yeah. Judge, the other, I don't know what else is on the 2 o'clock docket. The other two that I have first is Mr. Fizer. We are prepared to go to an evidentiary hearing on that. And then Mr. Gamble, he would like to enter an admission to the bench.
All right, Mr. Gamble then.
Mr. Gamble, please. We can take Mr. Fizer if the court would like. We are prepared to go to an evidentiary hearing on that.
Well, we've got to have a hearing on Fizer, and Gamble wants to enter a plea.
So, Mr. Gamble first, please, yeah. I don't know what else is on docket this afternoon. Trying to make efficient use of time. Your Honor, Tim Gibbs on behalf of Bren Gamble. Judge, this is 13 CF 641. We are here for an evidentiary hearing on a violation of probation. However, Mr. Gamble would like to enter an admission to the bench and proceed to sentencing today.
This is on 2013 CF 641 and 23 CF 1540.
Yes, Your Honor, that 23 CF case is tracking. It's a new law violation. It is in
Excuse
part
me,
the
Your Honor.
basis of the VOP. Yes, sir.
May I speak for myself, please?
What
Would
did
you
want to
raise
say?
your right hand to be sworn? You swear the testimony you give for his course is true, so happy God.
Yes, sir. Yes, Your Honor. The reason I originally violated my probation was because of the misdemeanor charge that was dismissed in December 2023. So that should leave me with no violation of probation. These new alleged charges are charged as new law violations, which I was already processed for the violation of probation, and
Mr.
I
Gamble, you're
don't
still-
understand.
Hold on, you're still on.
Sorry, Your Honor. Yes, these new alleged charges, they shall only be technical, if I'm not correct, right?
Well, I have a violation of probation case number and a different case number with several felonies on it.
So, Judge, that 23 CF 1540 case, that involves allegations that while he was being held in the jail, he allegedly tried to flood the cell. About 4 corrections officers had come in to restrain him. During that time, an altercation occurred that led out into the pod. Allegations include that he had gotten hold of one of the tasers.
I mean, is he trying to enter a plea to that?
So he's pleading to the VOP. That was added to this violation of probation, Judge. The reason that he was in jail at the time is he had a misdemeanor charge that has since been dismissed. That's what he's bringing up, Judge, is that he has a misdemeanor charge that has since been dismissed. The idea there being that if that misdemeanor was being dismissed, why was he held in the jail at the time, and thus why did these charges ultimately happen? But because he's still on probation while the charges happen, that's why it was added to the VOP.
Your Honor, there is something else, maybe the state objects to him pleading only to the violation of probation, because that would mean splitting the sentencing guidelines, and that's against the rule of law in Florida. If both cases are pending in front of the court, there should be one score sheet used, and he should be sentenced of both VOP case and the new law case. In any event, he's charged with a second-degree felony right now as a new law for an aggravated assault on law enforcement officer, correctional officer, for shooting the taser in the direction of the correctional officer. We have video evidence of that.
I'm not going to accept a plea on all this with...
He was just pleaded to the home invasion robbery. He does not want to plead to the new case, and I'm objecting to that. I want him to plead to everything, or we wait for trial, we go to trial, and he gets sentenced.
I'm not going to break this up into pieces.
So,
Your Honor, there's no violation of probation.
Well, that may be true, but I'm not going to accept a plea in pieces on this kind of case. I mean, this is...
so
Your Honor, if I may also, my offer...
I'm sort of confused on what's going on.
the new law case is the basis for the VOP, Judge. That's essentially what
And
we're
that
doing.
is pending.
And that's, both of those are pending.
Well, then that needs to be worked out with the VOP,
Yeah,
contiguous.
We did previously, we actually got an offer today, Judge, from the state for 5 years DOC with credit for time served. The main issue there is that, of course, he already has some DOC time in on the 2013 VOP case, but of course, not nearly as much credit on the new law. But that was the offer the state had made. That was the most recent offer the state had made.
Your Honor, as opposed to seeking, if we go to trial, the state will be seeking prison releasee reoffender status. He was released from DOC.
I don't want him to enter a plea to something that could be disastrous for him.
The strategy
And
on entering the
don't-
admission, Judge, was to enter the admission and resolve the VOP first, but
No. Y'all work on seeing what you can do about getting this straightened out. I'm not going to accept a plea. It might just be terrible for him, especially if they're talking about
and he's
prison
not-
release, reoffender status, and all that kind of stuff. So May 30th, we'll see you May 30th. No, that's probably not enough.
624, Your Honor.
6/24, and perhaps we can get it, y'all can get it worked out.
We'll certainly
I'm
keep
not
trying.
letting him enter a plea, which could end up really being terrible. And if he wants to go to trial, we do a trial. If y'all work it out, good. But I'm not certain I understand what he's doing. So 6/24. Thank you.
All right. Thank you, Judge. We'll wrap that up later. So, all right.
Your Honor, would the court be willing to give Xavier Thomas a continued arraignment date that we had mentioned earlier, since he's still not here?
Why is he not- why
The
was he
state-
not-
The state had indicated they had no objection. This is the one where my assistant had texted that he had called. He was broke down on the side of the road.
Oh,
He's coming
okay.
from Alabama. If we
Yeah,
could
bring
get
me some piece of paper from my mechanic says he was broke down.
If we could get a new court date.
Next, what's the next arraignment date? May 30th.
Thank you, Your Honor.
And some kind of piece of paper saying that, showing that was broke down.
Yes, sir. Thank you.
Your Honor, the only other case that I have is Mr. Fizer. It's a VOP evidentiary hearing, but I do see Mr. Keach and Ms. Merrifield here. I don't know if they also have cases if they were prepared.
How long is Fizer going to take?
30 minutes,
If that.
if that.
We'll do that one.
That's fine with me, Judge. Let's do it at the table, yeah.
All right, the state of Florida versus Travis Lee Fizer, 23 CF 2124, violation of probation evidentiary. State ready to proceed?
Ready, Judge.
All right,
Just going to call probation to the stand.
Mr. Berry.
I'll do it.
You want me to swear him or you want to swear? Would you please remain standing, raise your right hand, and be sworn?
Do you swear or affirm that the testimony
I do.
Have a seat, thank you.
Yes, sir.
Please state your name for the record.
Charles Berry, Jr.,
What's your occupation?
Senior Probation Officer.
How have you been a probation officer?
33 years.
Are you familiar with the defendant in this case, Mr. Fizer?
I did not specifically supervise Mr. Fizer, but I do know him.
Does your office keep records of probationers?
Yes, sir.
Are those records kept in normal business of your office?
Yes.
And do you have a record in front of you?
I do. One that you provided or that we did, it's a violation of probation done by Officer Kelly.
And was the defendant read his obligations at the beginning of probation?
Yes, he was instructed on the terms and conditions of, in this case, it was community control.
Okay. And when did the defendant get on community control?
February 29 of this year.
Okay. And when was his alleged violation?
March 24 of 2024.
So around how many days is that? Is that less than a month?
About a month.
Okay. What was the alleged violation?
He is currently on GPS monitoring, and he left his unit behind and was not next to it.
Okay. And can you elaborate, what unit are you talking about?
A GPS tracking unit. He has a unit that he has in his hand, much like a cell phone, and then one attached to his leg. Those two things have to stay together to communicate. If you leave the one that looks like a cell phone here and walk to the bathroom from here, it would tell you you're away from the unit.
Okay. So a probationer can have the ankle monitor on, but they could leave the unit behind somehow.
Correct. It honestly looks just like this.
Okay. So what use is the ankle monitor if the unit is not near it?
It tells that he's not near it and is no longer tracking him.
So on March 24th, what occurred?
Per the report, he left his unit at home and walked to a neighbor's house. He was gone approximately 19 minutes before they came back together, the ankle or himself and the unit. And that's the problem with the GPS.
So
the second violation was he's on house arrest and he wasn't supposed to walk to the neighbor's house.
Okay. What use is the ankle monitor if the unit is left?
It isn't.
So we don't know. Do we know what he did?
I have no idea.
Is it alleged that anything bad happened?
Not that I'm aware of.
But that's not the violation.
That is correct.
Okay. So what happened on the 25th? So that happened on the 24th. He left his unit behind. What happened on the 25th? Well, actually, my apologies. Did someone from probation call the probationer on the 24th and ask what happened?
Yes.
And what was relayed to your probation officer?
I'll have to look at the report because, once again, this wasn't mine. He stated that he went to the neighbor's house. He forgot it's called an RTC, or the tracking device. And his officer at that time instructed him to keep that device with him at all times.
And that happened on the 24th?
That is correct.
Okay. Is there another violation?
It's the violation it's on the 24th also.
Let me rephrase the question.
Right.
Was there another violation on a separate day?
Per this report, I don't see one. I do see where his officer contacted him on the 25th.
Hang on one second.
All three of these allegations have a date of the 24th, not the 25th. All three of these allegations stem from one event that happened on this one
I'm
day.
going to give you a chance to ask him questions.
But I just wanted to make sure the questioning wasn't directed too far out.
Well, I was going to give you a chance to ask questions.
Thank you, Your Honor.
What happened on the 25th? of March.
The only thing I see on this report on the 25th is when his officer spoke with him and asked him what happened on the 24th.
So are you looking at subsection 2?
The offender statement?
Correct.
Mm-hmm.
So what does it say that happened on the 25th?
It says on March 25, at approximately 8:05, the probation officer contacted him and asked him what happened yesterday on the 24th. And the offender stated he left his unit at home and he walked to the neighbor's house.
No further questions.
Do you want to ask a question, Mr. Gibbs?
Several, Your Honor, if
All
I may.
right, go ahead.
Good afternoon, Mr. Berry, or
How you
Officer
doing,
Berry.
Mr. Gibbs?
We've seen each other quite a lot in this courtroom, haven't we?
Yes, sir.
So, first and foremost, of course, you weren't actually Mr. Fizer's probation officer, correct?
That's correct.
And how long you been with the department?
33 years.
I'm not going to tell you how old I am then.
Okay.
So, the GPS that he's supposed to be on. Now, actually, let's back up from the beginning. You never instructed him on his directions, correct?
No, sir.
You don't know what exactly was told to him as far as instructions were, right?
No, sir.
All right. As far as the GPS goes, you didn't create it, correct?
No, sir.
You don't know how it's manufactured.
No.
You don't know how it works.
No, sir.
You just get a readout on a computer, correct?
That's correct.
And you have an instruction manual, maybe.
Oh, yeah.
Have you read through the instruction manual?
Me personally?
Correct.
No.
So as far as you know, you're handed this device and you're told how it works and you hope to God it works, correct?
Correct.
Now, we talked earlier about how it has two components, one that's strapped to the leg and one that actually is connected and plugs into the wall, correct?
Correct.
So this component, if you don't, you have to charge that thing quite often, don't you?
Yes.
What you do know about this component is you have to charge it overnight almost, correct?
A good 8 hours.
Good 8 hours a day?
That's what we ask them to do. They don't, but 4 is appropriate.
Four each day is appropriate for 4 hours. Now, you don't know Mr. Fizer's sleep schedule or anything like that.
No.
You don't know what his actual schedule was as far as community control, correct?
No.
Pretty much everything that you know about this case comes from somebody else telling you something, correct?
Correct.
All right.
The report.
The report, because you weren't there, and his probation officer's not here, are they?
The one that submitted this report is out on leave. That is correct.
So, now, also, he's on community control, correct?
That is
Means
correct.
he's got to have a schedule, and it's pre-approved and things like that, right?
Correct.
So as far as everybody knows, he was at home, even when this alarm went off.
I disagree with that.
Why so?
We don't know where he was.
But he could have been at home.
Could have been at home.
Could have
but
been at his neighbor's like he apparently said, right?
That's what he said.
That's what he says.
Mhm.
I mean, source of information is sometimes just as important as the information itself, isn't it?
Right.
Right. So, but you also otherwise testified that you have no idea where he was, what he was doing.
No, we know where the unit was.
That's it.
Correct.
Now, you know where he lives, though, right?
Me personally?
Yes.
No.
You never heard of a place called Griceville?
I know where Griceville. I don't know exactly where he lives.
Okay.
I know the vicinity he lives in.
Does he live in that vicinity?
I don't know his address. 5170 John Jones Road.
5170 John Jones Road?
John Jones Road.
5170 John Jones Road?
Mm-hmm.
And his neighbor is what, 5160? Is that correct, according to the report?
I don't see Ms. Gibbs, I don't see a...
You don't see what his neighbor's address is?
Mhm. It's a rural part of Baker, Florida. Actually, that's Holt, Florida.
That's the whole area, correct? Which is south of Baker, correct? Okay. But it's just as likely that he forgot it on the charger and walked outside to hang out in the yard, right?
He could have.
I mean, he even told you in his own statement, or told his probation officer, I forgot it, correct?
That's what the report reads, that he stated he
And as
forgot.
far as the reports that you have, there's no prior violations on this term of supervision, correct?
No, he hadn't been on long,
So he just forgot it.
per the report.
Thank you. No further questions.
Anything else, Mr. Sprous?
No further questions.
All right, thank you, Mr. King.
Yes, sir.
Next.
We'll call the defendant to the stand, Judge.
Just stand over here. Please remain standing, raise your right hand and be sworn.
Good afternoon. Sir, please state your name for the record.
Travis Lee Fizer.
What are you on violation, or what are you on probation for?
Sex offender violation, failure to update vehicle ownership.
Probation read you the obligations and the conditions
Yes.
and the rules that you're supposed to follow, correct?
Yes.
So on March 24th, you chose to leave your RTC.
Objection, that's argumentative.
Yeah, rephrase it.
On March 24th, you left your RTC at the house, correct?
I would actually object on leading, Judge, even
I
though he
forgot it
doesn't have
inside
those-
the house.
Overruled.
Thank you, Judge. Sorry, you can answer the question, Mr. Fizer.
You can answer the question.
I forgot my tracker inside the house on the Charger when I went out into my driveway to my neighbors, which is, we share a driveway, because I don't have a vehicle anymore. So my neighbor has to go to the store and get groceries for me. And I went outside to get the groceries from him and forgot the tracker in the house.
And that took you 19 minutes?
I was out there and I guess my wife called or tried to call me, and I'd left my cell phone in the house too. And I was just out there talking with him and getting the groceries from him.
I have no further questions.
Mr. Gibbs.
Did you testify earlier that you forgot your charger?
Yeah.
Had you ever done that before?
No.
I'm going to move over to the podium. Have you ever been on GPS before?
For, what is that, pretrial?
For pretrial supervision while this case was pending?
For this case.
For this case? On the underlying charges?
Yes.
Did you ever get a violation on that?
No.
What were you doing for 19 minutes?
Just out there talking to him.
To who?
My neighbor.
Who's your neighbor?
Greg Grims.
Gray Grims?
Mm-hmm.
Did you contact probation, or did they contact you when this alarm went off?
They called me.
Did you answer?
Mm-hmm.
What'd you say?
I said I was at my neighbor's, but I share a driveway with my neighbor.
What does the property look like that you live at?
You go down John Jones Road to the end of John Jones Road, the driveway goes in, there's a house and a trailer, and I live behind the house.
So it's kind of like a separate building or an outbuilding on this property?
I'm pretty much in my neighbor's backyard is my front yard.
Okay. What's the address?
5170 John Jones Road.
How long have you been there?
A little over a year.
So when probation says that you told them that you were at your neighbor's house, you were essentially outside your front door?
Yeah, it was in my driveway, actually.
Did you go anywhere?
Nope.
What happened how did you get notified that probation was contacting you?
My wife called, tried to call me and said my tracker was going off and it was in the house. And I looked down and it wasn't there, so I ran back in the house and...
So there was never any intent in your head to do anything wrong?
No.
No further questions, Judge.
All right, thank you. You can have a seat. The next witness.
State rest, Judge.
Defense rest, Judge.
Judge, the state's concern is it was less than a month of the defendant being on the GPS and he's already violated. Through the testimony, it's clear that he is familiar with GPS monitors, but yet he still chose to leave his monitor in his house when he left the residence. So we don't know really what happened, which is the whole purpose of the GPS.
Two main points, Judge. First, everything that we've heard about whether he was supposed to be on GPS, et cetera, that didn't come directly from Mr. Fizer actually came from hearsay. That probation officer is not here. That affidavit is hearsay. That is an out-of-court statement offered for the truth of the matter being asserted. Reversal of an order revoking probation based solely on hearsay is not admissible, is not allowed by the law. That's Chavez v. State in 527 Southern 2nd 943. It's a 1992 case. So first of all, the court, even if it does find that he violated probation even on technical grounds, can't revoke and terminate his probation. This is not a willful violation, Judge. Even his own testimony, even the statements that he gave to probation when they first contacted him, I forgot. There's no allegations of any other offenses as far as we know, based on what he said, based on what probation knows. He was simply in his front yard or at his neighbor's house next door. He was charging his device as is required for 4 hours a day. He was charging it. He's not out there committing new crimes. Yes, we know where he is. The second issue that I have, Judge, again, it has to be willful and substantial. This is a technical violation. And secondly, this is not willful. By his own admission, it's not willful. That's Thorpe v. State, which is a first DCA case, 642 Southern 2nd, 629. It's a 1994 case out of the first DCA. So even if he inadvertently committed a technical violation, there is no willful violation here, Judge. We'd ask that you find that he's not in violation.
How long has he been on, how long was he sentenced to community control?
I'm not sure on the top of my head, Judge, what his original community control sentence was. There is a minimum mandatory that is required when it comes to being sentenced. It would have been at least 6 months, anywhere from 6 months to 2 years.
What was his sentence, Mr. Berry?
I gave the report back to the state attorney. If you'll let me refer to it, I'll let you know. Your Honor, he was placed on...
Judge, based on the plea agreement from February 26th of this year, he was placed on 6 months of community control, followed by 1 year of standard probation.
All right, he's in violation of his probation. He admitted he was at the neighbor's house and he didn't have his monitor with him. His court sentences him to 30 days extra standard probation tacked onto the probation he's already serving.
Thank you, Your Honor.
Thank you, Judge.
His probation's extended 30 days
Yeah,
from the original term date.
yeah.
Okay, thank you. Thank you, Judge. Your Honor, I believe that concludes all my business.
All right. Next one is Philip Lee, 2020 CF 2658.
May we approach just briefly?
Yeah. You want to be on the record?